Hello everyone, welcome to our fourth lecture on professional responsibility for NCA. So today we are going to cover two important topics. So under topic C, some specific practice areas. The first topic is ethics and dispute resolution, in which we are going to talk about how a lawyer can help as a counselor, as a negotiator. So we'll be talking about alternate dispute resolution methods, and specifically as per syllabus we are going to cover only two of those, counseling and negotiation. Then we'll talk about how ethics and practice of criminal law works. So these are the two topics. Firstly, under counseling and negotiation, the first topic is when does a lawyer-client relationship come into exist? Earlier we studied this as a retainer agreement, that simply how a lawyer-client relationship comes into an exist when just a client visits lawyer and share few important details. Even those details are in administrative nature. The lawyer client relationship starts, begins. Then how a lawyer acts as negotiator, mediator, arbitrator. Then disclosure, obligation, responsibilities on part of a lawyer. Lies, misrepresentation, misleading, truth. Are these differences? Are there any differences here? Then where does conflict of interest occur in these situations? Then confidentiality, secrecy, to what extent a lawyer has to keep things secret, confidential. Then are adversarial rules helpful? Expanding nature of legal services, collaborative lawyering. So these are few topics that we are going to cover under first head. Second is ethics and practice of criminal law. Firstly, we already studied that the lawyer-client relationship exists. That topic we covered earlier. So the second topic from where our today's lecture begin is related to private settings. So there are two tasks that are frequently asked by a lawyer in relatively private settings. So here you don't have any court setup, you are not going before a judge, you are not going before a court of law, but you are taking your clients before a private setting where a third neutral party will give the decision. So how a lawyer's responsibility, professional responsibility comes into picture in these cases. So counseling, giving the client information, opinion and advice. Here under counseling, the lawyer not only delivers information but also provide an opinion on the true content of the law, that whether your case is strong, weak, what are the things that you have to keep in mind. So basically all the information, opinion and advice. So firstly we'll be talking about this topic in detail, then we'll take up the negotiation part. So what are the important ethical issues on part of a lawyer when a lawyer counsels, gives advice, gives opinion to a client? So here the first ethical issue comes into picture, that whether a lawyer can ever advise his or her client to break the law. Then the extent to which lawyer can provide advice that could be used by the client as the basis for a subsequent decision to break the law. Then lawyers have a duty to be honest and candid. Their advice must have clarity and be articulated in terms, language that is clearly understood by a client. So what professional conduct's model code says? So there are few rules related to this under counseling. What are the professional responsibilities of a lawyer? So rule 3.22 says a lawyer must be honest and candid and must inform the client of all information known to the lawyer that may affect the interest of client. Here your duty is not to just please the client. You have to tell clear picture to the client. Then under another rule 7, a lawyer must never knowingly assist or encourage any dishonest. So the first issue that we discussed earlier, that whether a lawyer can advise his or her client to break a law. No. Dishonestly, fraudulently, you cannot assist or encourage anyone to break a law. So as per rule 3.27, a lawyer must never knowingly assist or encourage any dishonesty, fraud, crime or illegal conduct, or instruct the client on how to violate the law and avoid punishment. Then 3.28, a lawyer who is employed or retained by an organization to act in a matter which the lawyer knows the organization has acted, is acting or intend to act dishonestly, illegally, must do the following. So if a lawyer is employed by a law firm, and that for law firm the lawyer knows that is doing something that is dishonest, illegal, then in those cases there are few responsibilities that a lawyer has to perform. First, inform the person, the client from whom the lawyer takes instruction, and chief legal officer or both. So here, firstly, the person who gave information to the lawyer that you have to do such and such thing, from whom he has been getting instructions, like his manager or senior lawyer, whosoever he or she is, then chief legal officer or both. So advise those persons that the proposed conduct was or would be dishonest, fraudulent, criminal, illegal, and should be stopped. If necessary, the person from whom lawyer take instruction, the chief legal officer or CEO, refuses to cause the proposed conduct to be stopped, advise progressively the next higher person. So whoever is the next higher authority, or ultimately board of director, board of trustee, the appropriate committee. So tell all those higher authorities that particular such and such thing that the law firm has been asking me to do is of criminal nature, fraudulent, and should be stopped. So if the organization, after all the efforts by lawyer, despite lawyer's advice, continues to do such thing, then the lawyer can withdraw from acting in that particular case as per rules given in section 3.7. So this is important. This is the first thing that a lawyer should do. So many lawyers misrepresent their knowledge and experience to gain a client's confidence. As I told you earlier, you cannot do this. You are not here to please the client. So you have to be truthful, you have to be honest. Where a lawyer is providing business or financial advice, they should clearly differentiate between this advice and their legal advice. If a lawyer discovers that they have made an error, then the lawyer should immediately notify the client and discuss how to clear that error and how to make that error correct and proceed further. A lawyer should insist on independent legal advice in connection with any of the client transaction in which lawyer has an interest. So in case the lawyer has a personal interest or financial interest in any matter, then the lawyer can straightforward tell the client that okay, I have interest in this particular case, or I know the other party. I insist you to hire some other independent legal authority. Independent here means who is unbiased, who is not discriminatory nature, who has no personal interest. Model Code 3.2 encourage compromise or settlement. So a lawyer must advise and encourage a client to compromise, settle a dispute whenever it is possible to do so on reasonable basis, and must discourage the client from continuing useless legal proceeding. So here it means if the lawyer thinks that the case is very simple and the person doesn't need to go to court and you know pay expensive lawyer fees or things like that, then the lawyer is always advised, always expected to advise his or her client to go for outside court settlement, which is like this case of counseling, negotiation, arbitration, mediation. So here under counseling, why are we reading all these rules? Because under counseling, a lawyer's duty is just to give advice, opinion about a particular matter to a client. So here what a lawyer has to do. So this is the main thing that a lawyer is expected to do so that the client can save time and money both. So MC commentary, a lawyer should consider the use of alternate dispute resolution. So David Levin's commentary again talks about the similar thing, that it's the lawyer's ethical duty as the role of confidential counselor, legal advisor to their client, and also the lawyer should tell that as per this and this particular law, as per this and this rule, your outcome would be this. So role of counselor and advocate are necessarily different. They are not same. Counselor is expected to provide client independent, candid advice. Counselor is just a person who just tells a client that okay, your case says this. This is the position of your case. Counselor is not going before the court and fighting for your case. So this is the main difference. He's just informing the client what the law mandates, even it is not what the client wants. So rule of thumb should be, if your view of the law is out of mainstream but you believe you are right, you have the responsibility to tell your client both those things, what the law requires and the fact that your own best understanding is not one that the law interpretive community would accept. So this is the thing. As a counselor, you can give your personal opinion outside the law, but you have to tell your client as a counselor that okay, this is not what law says, this is but I am saying as per my understanding. Then next is negotiation. So counseling, we understood, just you are advising your client. Under negotiation, you are actually negotiating. You are coming to a common conclusion. So this area is subject to quite minimal legal restriction imposed by law on fiduciary duty, deceit, misrepresentation. People can essentially act in their own best interest and have autonomy to negotiate unethically if they choose. So negotiation means you are not bounded by any strict rule of law. You can act as per your own interest. Negotiation means there are two parties. You are saying you can, I am giving, like there is a dispute between two person A and B regarding some noise level coming from B's apartment. So A complains that B's music is too loud, especially late at night, and it disturbs their sleep. So B, on the other hand, enjoy listening to music at unwind after a long day at work. So here, as a negotiator, your responsibility is not always as per law or as per ethics. You have to come to a common conclusion which suits both the parties. So here, what you will do in A versus B case, you will set a stage. A and B agree to meet at a neutral location to discuss the issue peacefully. Then A can say B that I have been trouble sleeping because your music is too loud, this and that. Then B can tell that okay, I understand A, I play music to relax after work. I didn't realize it was bothering you. So here A's interest are peaceful and quiet environment for sleeping, and B's interest is to enjoy music. So here what as a negotiator you can do, A can say that using headphones soundproof would be really appreciated. Then B can say that okay, I will start using headphones after 10 p.m. So as a negotiator, both the parties will express their concerns and issues before you, and you have to just find a solution that respect both their interests. So this is the thing, very simple setup. So negotiating parties are permitted to withhold material facts from one another and make untruthful statements. Like a game of chess or poker, bluffing are key tactic. The critical difference between those who are successful negotiator and those who are not lies in the capacity both to mislead and not to be misled. So where is this negotiation concept covered under model code? So rule 7.2 says that communication with any person, whether or not a party to a formal legal proceeding, contract, negotiation, who is represented by a lawyer concerning the matter to which the communication relates. Then rule 6.1 talks about delegation. Then rule 3.4 talks about negotiations again. So in Ontario, what happens, the lawyers negotiating settlements are governed by the rule of professional conduct of Upper Canada. So they are there also guided by the model code of professional conduct. These rules define competent lawyer, that lawyers are required to advise and encourage their clients to compromise, settle a dispute wherever it is possible. So this we read in the last part of counseling as well. So it's always a duty of a lawyer to ask clients for a compromise, for a peaceful settlement, to use ADR, alternate dispute resolution method, and one of the method is this negotiation. So there are so many cases which talks about negotiation, counseling, what are the issues that lawyers face. So I have added few extra cases in the notes. You can read from there. Few important ones we are discussing today. So first is Westcom TV Group Limited versus CanWest Global Broadcasting Incorporation. So in this case, judge in paragraph 1819 explained the difference between misrepresentation in term of party's intention from misrepresentation in regard to subject of the contract. So there are two kind of misrepresentation. First, a party intention, a party's mind, the way they are coming up with the case, that is misrepresented, or the subject of the contract is misrepresented. So Justice Lowry expressed hesitation in using the word or term misrepresentation when describing concealment of a party's intention. Misrepresentation is correlated with term used in tort law. Parties involved in arm's length negotiation commonly conceal their true intention. Positions are advanced but do not represent what a party truly expressed or is prepared to agree in them. It is a part of negotiating process that positions are advanced that do not represent what a party truly expect or is prepared to agree in then. Party may well say it will pay no more than stated amount or agree no more than a limited term, when in fact it would pay or agree on a longer term in order to conclude a deal. So here for lawyers, the judge has clearly said that don't go by the party's intention or saying at the beginning. In negotiation, we are not following any strict laws. So it doesn't matter that if a party has said something in the beginning, they will stick to that thing only at the end. So this is what the court has cleared out. So negotiating parties often hire lawyers to negotiate on their behalf. So as a competent lawyer, you have to apply your relevant knowledge, your skill, and bring that matter to solution in an appropriate way. So this is what a competent lawyer is expected to do in negotiation. So what are the rules of negotiations? Most provincial code of ethics contain obligation that lawyer must, in dealing with other lawyers, self-represented opposing party, like in negotiation, etc., act with integrity. No matter it is an outside court process, if you are representing some party, you are a lawyer and you are acting as a negotiator, you are expected to work integrally and with good faith. So having lawyers engaged does not change the customary degree of deception. Need to respect lawyers' obligation to promote the interest of their client is important. If lawyers are more restricted in their negotiation tactics, clients will be tempted to forego the use of lawyer. So the lawyer are not expected to be restricted. So as I said in the previous slide also, that here in negotiation, you are just helping two parties to come to a common solution. You don't have to go by the exact words, exact legal terms. Concerns about misrepresentation are better left to other areas of law. Drafting a rule about what is and what is not permissible negotiation is a difficult exercise. Advocates of enhanced regulation in negotiation argue against this justification and claim that lawyers' duty and obligations are balanced in many other realms and there is no reason why they cannot be balanced in negotiation. So although lawyers sometimes feel little upset with this kind of setup, that how being a lawyer they're expected to go by the rules in other setups and not in negotiation, but this is what negotiation is all about. Negotiation is opted by those parties who don't want to go by the strict rules of law, who just want a flexible, peaceful approach towards settlement of a dispute. So then there was another case of Law Society of Upper Canada versus Sussman, Counseling and Illegal Conduct. So a solicitor Sussman was a member of Bar of New York before being called to member of Ontario. Solicitor is charged with, while acting for a wife in a matrimonial proceeding, he counseled his client to breach the terms of the court order respecting access. So here solicitor gave illegal advice. So issue is whether solicitor's counseling of his client constituted professional misconduct. So here what held, solicitor counseled his client to breach the terms of court order. A finding of professional misconduct against the solicitor is established, no doubt. So here illegal conduct is definitely there. It is clear that solicitor counseled his client to disobey, flout the terms of order of judge, even admitted to doing so in evidence. So here what held, the counsel was suspended from practice for 1 month. So that was the first topic of counseling and negotiation, and all the other topics are related, that those are subsumed in those two topics only. Like collaborative lawyering, it means when a lawyer works as a mediator, negotiator, as outside court party. So those all topics comes under negotiation and counseling only. So you don't have to focus on those separately because those are repetitive in nature. Then next topic that we are going to cover today is ethics and practice of criminal law. So for this we'll be seeing how as a crown counsel, how as a defense counsel the lawyer has few important professional responsibilities. So in R versus Boucher, the role of crown counsel excludes any notion of winning or losing. So neutral position. So a crown counsel has a neutral position. This was what held in this case. Then in R versus Stinchcombe, the position of defense counsel came into exist. So they say defense counsel is entitled to take a purely adversarial approach. So defense counsel has no responsibility obligation to assist the prosecution and is entitled to resume a purely adversarial role, purely oppositional party role. Defense will try to win the case anyhow. But a crown counsel is a neutral position. However, these assertions are not always entirely true. Both Crown Counsel and Defense Counsel have their own roles in criminal trial. Crown Counsel is expected to act fairly, objectively, dispassionately, but also to contend convincingly for a rightful result. So this is the duty of a Crown Counsel. On the other hand, a defense is expected to vigorously, spiritedly represent the interest of accused, also anticipated to remain independent, unbiased from client, and mindful of various courts' overriding duties to them. Through various important landmark cases, we will be seeing ethical duties, firstly of Crown Counsel. So Crown Counsel in Skokman versus Queen held that are in different position from ordinary litigant, for they represent public interest in the community at large. Crown Counsel is a lawyer advocate who is acting on behalf of government. So a community's interest, public interest is the main thing that you have to keep in mind. So here public interest is involved. So it is a different position, different responsibilities, more responsibilities. Crown Counsel conduct the prosecution in criminal case. So whenever there is a criminal case and a party has to represent through a government lawyer, so their Crown Counsel comes into picture. Is subject to conflicting obligation that must be balanced. So duty to advocate and work ambitiously to accomplish a conviction where warranted. So this is the first duty. Then duty to be fair and objective towards the accused. So if you are Crown Counsel, it doesn't mean you can be unfair toward the opposite party, toward the accused, and you will only have to think about your client. So here again I'm saying public interest is involved. You are acting on behalf of government, so you have to be exceptionally fair and objective. Public interest consideration require Crown to exercise judgment, discretion, which go beyond functioning simply as advocate. You are not here just representing your client, you are representing a whole community. Counsel appearing for Attorney General are considered ministers of justice. So these people are part of court of law. These are considered as ministers of justice. Fairness, moderation, dignity should characterize their conduct. In Boucher versus Queen, the role of prosecuting counsel in Canada is to promote the cause of justice. It is not his function to persuade a jury to convict any other person by reason. His function is to ensure that all proper evidence, proper inferences are drawn, placed before jury, together with a reasoned argument as to conclusion to which such evidence and infer lead. So they are ministers of justice. This was held in this particular reading. So in examination, if you get a question on a Crown Counsel duties, on a Defense Counsel duties, sometimes you get a straightforward question that whether a Crown Counsel holds more duties or more legal obligation, ethical obligation than a simple advocate. So there you have to mention all these important readings as your references, these important cases. So firstly, full disclosure. Being a Crown Counsel, it is your duty to make full disclosure of to the defense of all relevant, pertinent, your case specific information in Crown's possession. Whatever is with you, everything that is important for the defense to know. You have to make full disclosure of all those things. So in R versus Stinchcombe, Parliament and Supreme Court of Canada fundamentally changed the law, and this gave rise to modern ethical constitutional duty to make full disclosure. So this is ethical as well as constitutional duty now. Then Crown's duty to call all material witness. So Crown's non-adversarial role as a quasi-judicial minister of justice include duty to call all credible material witnesses whosoever could be important for the case. Crown's role is to put before jury what the Crown deems to be credible evidence. Whatever Crown feels is important for the case, the Crown's duty is to bring that forth before the jury. In Lame versus King, long established rule, the prosecutor has discretion to determine who are material witness. Discretion will not be interfered with unless it was exercised for an oblique motive. Unless there is some bad motive, it is the discretion of the prosecutor, Crown Counsel to decide what all things are material, what all things could be bring forth before the court. Overzealous advocacy by Crown Counsel. So, there are some legal ethical limits on Crown Counsel's advocacy at trial. In R versus Sugarman, the Crown has no interest in procuring a conviction. Its only interest is that right person should be convicted. So Crown Counsel can never show that by anyhow he or she is just trying to, bring the opposite party for conviction, or you can see that the Crown Counsel is doing something overzealously. So Crown Counsel's duty is to bring forth before the court all the material evidences that could lead to opposite party's conviction. So just to bring before the court the truth, the important material credible evidences, that the truth should be known and the justice should be done. So these should be important things that are expected from a Crown Counsel to be done. At no way a Crown Counsel should show his or her interest in procuring a conviction. Jury addresses. As part of Crown's duty to be fair, they are obligated to make certain that any commentary made during jury addresses are not inflammatory, should not be derogatory. Two limitation on content of Crown jury addresses. Firstly, entitled to examine all the evidence and ask the jury to come to conclusion that the accused is guilty. So in no way Crown can do so. Duty to assist the jury, but exceed this duty when he expressed by inflammatory vindictive language or show his personal opinion that the accused is guilty. Crown Counsel can never do that. So these are two limitations on the content of jury address. So you have to keep one thing in your mind at every step. You have to mention this thing, that at no stage a Crown Counsel should show his or her intention to convict the other party. The only duty, only thing that you expect from a Crown Counsel is that he or she is just trying to do justice. Ethical duties of officer of court. So both the Crown and Defense Counsel are considered as officers of the court. So as officers of court, they have absolute ethical duty to tell judges the truth, including avoiding dishonestly. Then location of documents, other matter related to conduct of the court. So Lord Reed in Rondell versus Worsley says that counsel must not mislead the court, must not lend himself to casting aspiration on the other party. There is premium placed on counsel's dishonesty and integrity, otherwise it will be quickly undermine the search for truth and justice, which is the main motive of a Crown Counsel. Then duty of civility in R versus Felderhoff. So as per Roy McMurtry, Chief Justice of Ontario in Advocate Society Advocacy in 21st Century, he says lawyers are not solely professional advocates or hired guns. While they do not surrender their free speech rights upon admission to bar, they are also officers of the court, with few obligation to uphold integrity. It is the duty of counsel to be faithful to both client and administration of justice. So this is very important in examination. You have to mention this thing. Both Crown and Defense have responsibility in providing relevant case law to assist the court. As per Model Code 5.1, Lawyer must be courteous, civil, act in good faith to the tribunal and all person with whom the lawyer has dealing. Then comes ethical duty of defense lawyer. So firstly, duty towards client in Rondell versus Worley, we just read this. Require counsel fearlessly raise every issue, advance every argument, ask every question, however distasteful, which he think will help his client's case. So here, defense counsel's duty is not just to represent. He will take every action, he will take every effort to make his client win the case. But provided everything is just under the law, under the rule of law, as per the Court of Justice rules, there is nothing illegal. As per Model Code 5.1, when acting as an advocate, a lawyer must represent client resolutely, honorably. So, like I just said, under the law, within the limits of law, treating the tribunal with frankness, candor, fairness, courtesy, and respectful. So lawyer's function as an advocate is openly necessarily partisan. Lawyer is not obliged to assist an adversary advance matter harmful to client case. So duty of confidentiality is important. Then defense counsel has duties of loyalty, confidentiality, honesty. Then what are the duties to court? So as I told you here, Model Code 5.1 says the lawyer has a duty to treat the tribunal court with fairness, courtesy, and respect. Then duty of honesty, the defense counsel have an obligation not to call evidence that is believed or known to be false. Has to be honest. Where an accused admit guilt to counsel, counsel cannot advance any evidence that would tend to contradict this fact. So this is important because otherwise the purpose of defense counsel would be unfruitful, because definitely defense counsel means you are the opposite party in a criminal case. A client comes to you, admits their guilt, so this is something confidential between a client and a lawyer. This is not something that if being a lawyer you know that your client has done something, you will try to defend your client by all the legal means. That does not mean that you will bring forth the court against your own client only, just because your client has hired you as a defense lawyer. So these are again few different cases in which duty of loyalty, confidentiality were highlighted, that these are important. So defending the guilty client and not misleading the court. So this is what I just told you. When defending the guilty client, the utmost vital ethical principle is to avoid forming any opinion. So it doesn't matter that a person has come before you, is trying to hope that you will save particular person, so that person is guilty, you know, but that doesn't mean that being a lawyer you form any personal opinion on the subject of guilt or innocence at the first place. So Crown Counsel should never express his or her personal opinion as to accused guilt in closing submission at trial. So neither Crown Counsel can do that nor Defense Counsel. So Defense Counsel's personal opinion in terms of client's guilt, innocence is irrelevant, can actually cause counsel to fail in exercising partisan duty mentioned above to resolutely defend the client. So if you are defending your client, you cannot make any personal opinion for your own client. So this is the basic thing that we all know. Counsel's role is neither to judge the client nor to arrive at a personal. So what a lawyer can do? So lawyer can only do bring important evidences, defenses that are not fraudulent or that are not false before the court and try to just defend his or her client. So as per Model Code 5.1 commentary, then commentary number 10 says that admission made by accused to a lawyer may impose strict limitation on the conduct of defense. Accused should be made aware of this. Like for example, a person is coming to you and making an admission that okay, I have committed particular crime, then the lawyer's duty is to tell that person that okay, you are admitting. For example, if the accused clearly admits to lawyer the factual mental element necessary to constitute crime, the lawyer, if convinced that admission are true voluntarily, may properly take objection to the jurisdiction of court, the form of indictment or the admissibility sufficiency of evidence must not suggest that some other person committed the offense or call any evidence that by reason of the admission the lawyer believes to be false. So here what happens, for example, you are a defense lawyer, a client comes to you and he says that okay, this is what I did. You know that your client has done, but it does not matter that before the court of law, you will put this blame on some other person. Your duty is just to defend your client. So there, whenever a case comes into picture, what you will do, you will only try to bring those evidences, those things before the court that can help your client winning the case. So counsel can obviously continue to defend the client even though they believe their client is guilty. So this is what I said, this is important. Taking custody and control of real evidence. So defense counsel who acquired possession of physical evidence is confronted by vexing personal responsibility issues. That is, client asks counsel to take possession of real evidence. Model 3.27a says that prohibit knowingly attempting to influence the court of justice. You cannot do anything that is fraudulent, that you are trying to mislead the court, or you are trying to forge any documents, any evidences by suppressing what ought to be disclosed. So whatever is required, like the real evidence that are required to be put forth before the court, disclosed before the court, you cannot suppress those things. Otherwise, assisting in fraud, crime, or legal conduct. So otherwise, it will be like you are assisting the crime if you are suppressing, not disclosing any real evidence and taking those things into your custody just to make your client win the case. So this is illegal. You cannot do anything with the evidences. In criminal law, there is generally no reciprocal disclosure obligation placed upon the defense. Stinchcomb case, absence of a duty to disclose is consistent with purely adversarial role of the defense. So as such, the basic things that being a defense lawyer you do, those are justified, but it does not mean that you can forge with any documents or anything that is like real evidence and take control of those things. And because there is no as such obligation that you have to reciprocally disclose the things before the court of law, because this is your duty, and absence of such duty means that you are doing your particular adversarial role as being a defense lawyer. But there are few limitations, and those limitations are in model 3.2. Exceptions to general rule against defense disclosure. Alibi should be disclosed in timely manner to permit it to be properly investigated. If a person is seen at two places at one time, you have to disclose this thing, but in a timely manner. Psychiatric defense should be disclosed in a timely manner to allow the Crown psychiatrist to analyze the accused. So these are important disclosures that you have to make before the court. Expert opinion evidence relied on by the defendant should be disclosed 30 days before trial. However, never a legal obligation on defense to disclose, but it's generally expected. Nonetheless, lawyers are not permitted to allow their privileged status to be utilized as a tactic or vehicle for disposing of any incriminating evidence. Criminal law prohibits such thing. As I just told you in the previous slide, that you cannot forge any document, you cannot incriminate any evidence. This is illegal. Crimes of obstruction of justice, accessory after the fact, both including the hiding of evidence, like I told you, non-disclosure, then disposing of evidence within their actus reus element. So it will mean like you yourself are an accessory, you yourself are helping your client in committing that crime. The only defense for a lawyer in possession of such real evidence as proven by Murray is a lack of mens rea, as the offense requires accused willful intention. So if in case something comes up before the court that the lawyer has helped a person, if the lawyer proves that he did not have any intention, mental element was not there in helping to incriminate the evidence, only then a lawyer can put forth that thing as defense. But otherwise, if a lawyer is intentionally asking the client to incriminate any evidence, that would be. So in R versus Murray, what happened? Critical tapes were overwhelmingly inculpatory, evidence that can directly establish the guilt of the defense client. They ought not to have been concealed by Murray. So Murray concealed. Defense counsel can take possession of real evidence and conceal it during the pre-trial period if, like I told you earlier, mens rea was absent. If the counsel honestly believe it has exculpatory in criminal trial, that he is not required to disclose before the court. If the counsel honestly believe this thing in good faith and that exonerate or tend to exonerate, absolve the defendant of guilty, opposite of inculpatory evidence which tends to prove guilty, uses at trial, and if counsel intend to use it at trial, lack of mens rea. So here lack of mens rea was proved. So exculpatory are those evidences that are favorable to the defendant in a criminal trial that can help the guilty party to be absolved of the guilt. Inculpatory are those that can directly prove your guilt. So here the defense counsel thought in a good faith that okay, this is exculpatory. If I'm going to incriminate, if I'm not going to disclose this before the court, that it will help my client winning the case. So this was what held. Negotiating a guilty plea and sentence. So plea bargaining concept. Duty of appropriate negotiate a guilty plea and sentence for a client who faces inevitable conviction at trial or for a client who wishes to acknowledge guilt regardless of his or her prospect at trial. So in this case, if your client is accepting your guilt at trial, there doesn't mean that your duty as a defense counsel ends. There you will have to act as a negotiator and you will have to ask the court to provide a reasonable sentence, like to reduce the reasonable sentence, the time period. So here, Model Code 5.17 says that before a charge is laid or any time after, a lawyer for an accused or potential accused may discuss with the prosecutor the possible disposition of the case unless client instructs asked for word. So if the client instruct otherwise, like say something else, then it's a different thing. But if a client says that okay, I am ready to accept my guilt, then the defense counsel can discuss with the crown counsel, the prosecution, all the possible dispositions, like a kind of negotiation. So Model Code 5.1 says a lawyer for an accused may enter into an agreement, like I just said, kind of negotiation with the prosecutor about guilty plea if following investigation. So in a guilty plea, the picture is clear that the person who is guilty has accepted his or her guilt, and now as a defense lawyer, you are bringing an agreement with the prosecution where you both will together help the guilty party to come to a conclusion, like he will definitely get sentenced, but the sentence will be lower down. So lawyer advises his or her client about the prospects, about acquittal or finding of guilt. So here few conditions, like you can come into a common negotiation agreement with the prosecution, but provided you have informed your client about the repercussion. The lawyer advised the client of the implication, possible consequences of guilty plea, that you could be acquitted or you might get imprisonment also. So the client should be aware of all the consequences. Client voluntarily, without any force, is prepared to admit the guilt, is prepared to admit the necessary factual mental element of the offense charge, and the client himself or herself instruct the lawyer to enter into an agreement which is known as guilty plea. So Model Code commentary says that public interest in proper administration of justice should not be sacrificed in the interest of expediency. So this is important. It does not mean that okay, you are fraudulently, you are misrepresenting your client by saying that if you accept your guilt, then you will get acquitted. No, a lawyer has to be clear about all these four things. So these four essential requirements needs to be met before going for a guilty plea. So four main ethical rules of defense counsel when conducting a plea and sentence negotiation. Sentence negotiation, as I told you earlier, that you are just helping your client in bringing down the sentence time period. So must not conclude plea sentencing discussion without completing thorough analysis of fact. Client is entitled to skilled advice. So you should not be in a hurry to bring your case to an end. You should still act as if you are trying to save your client. So here saving means you are trying to save your clients for extremely lengthy imprisonment. So client is entitled to skilled advice. Client must decide what plea to enter and it must be made freely and voluntarily. Plea must be based on an admission of necessary factual mental element of the offense charged. Public interest must not be sacrificed. So then there are few articles that talks about the good criminal law barrister. What are the traits? What should be there in a criminal lawyer barrister who is entitled as a good barrister? So firstly, concept of professionalism comes into picture. Canadian justice system recognizes special professional status of barrister who appear in criminal court. Professionalism means as a good criminal lawyer, you are committing to justice, to public good, a devotion to competence, learning, a commitment to ethics or decency, integrity. Then, for a defense counsel, ethical and moral consideration should be there. Like you should have full professional understanding, responsibility to examine, analyze the legal ethical boundaries that you have to exercise as per your role. Then, how administration of justice works. Then in Roundel versus Worsley, that this case we discussed earlier 2 times. So here again in this article of Austin, this case had been discussed. So it says that as an officer of the court concerned in the administration of justice, the defense counsel has an overriding duty to court, to standards of profession, to public, which may or often does lead to conflict with client's wishes or with what the client thinks are his personal interest. So counsel is prohibited from misleading the court, leading false evidence, even if your client wishes you to do so. Being a crown counsel, being a defense counsel, you have to be truthful. So defense counsel may interview witness, however, they may not coach them, advise them to what to say or to change their narratives. If they coach them or advise them improperly, they are at jeopardy of prosecution for attempting to obstruct justice. So you cannot mislead witnesses. Then there are some practical considerations that a defense counsel has to keep in mind. Like if the client insists on directing the barrister of the defense in a manner that the barrister deems unethical, gravely harmful to the case, barrister may have to consider whether to withdraw. So if your client says that the barrister is not doing something good ethically, if the client denies guilt, then the barrister is not allowed to enter into a plea bargaining or a guilty plea. So for Crown Counsel, ethical considerations include that Crown Counsel is an officer of court, they fill a public function, then there's a legal duty to make full disclosure to defense of evidence in their possession, then violation may lead to mistrial, stay of prosecution in R versus Stinchcombe this head. So these are few things that we have already discussed earlier, but here again in this Austin commentary, Austin article, these things have been taken up beautifully. Some practical consideration from Crown Counsel: limits on Crown prosecutor may cross-examine and accuse, then limits on the manner in which a prosecuting barrister may present his or her argument to a jury, then professionalism and desire to win. As I told you earlier, zealous, overzealous representation should not be there on part of Crown Counsel. So Crown Counsel in no way should say that I want the other party to be imprisoned. So Crown Counsel has to work only to bring justice. Then professionalism and civility. So has to be civil before the court, before the opposing counsel, before everyone. So counsel has a professional responsibility to respect the personal integrity of the opposition. It does not matter that whether you are before your opposite counsel, and you cannot use any kind of abusive language for your opposite counsel. You have to be respectful for everyone. Counsel has a professional responsibility to preserve the dignity of the forum in which they practice, the court. Then civility amongst lawyer counsel who have been entrusted with the administration of justice. Civility makes certain that issues before court are resolved in an ordinary way aids in preserving and maintaining role of counsel in the justice's honorable manner. So you have to be a dignified lawyer. So these were the things that were held in this Austin M. Cooper article. So in examination, if you are getting a question, again I am saying on how a crown counsel or how a lawyer should act in criminal cases. So there you have to firstly mention all the professional, ethical, practical considerations, what is expected from crown counsel, then what are the things that are expected from defense counsel, then you have to mention the cases, and in your analysis you have to mention these particular commentaries, rule of model code, then this last Austin M. Cooper case, because this beautifully summarizes the role of both crown and defense counsel. So this is how you're going to take up this particular topic, and in examination many times a question, even if it comes like 5 marks or 10 marks, comes on this topic because this is very very important. So this is how you're going to attempt, by referring to all these important legal sources. So that was end of our today's topic. Thank you and good luck.